Tonight's case moves fast and hits a lot of sensitive pressure points: competency, bond violations, and a GPS tether that was actually cut. On one side, we have Mr. Peoples, whose competency is being evaluated and whose anxiety is front and center in what happened with that tether. On the other, the court must balance public safety, compliance, and fairness, while not punishing mental health crises. You'll hear the judge weigh whether to keep him in custody or send him back to home confinement, how much a damaged strap costs, and what happens if another crisis flares up. Watch the moments of confusion about dates, a sharp exchange between the bench and the prosecution, and a practical fix to align bonds so release is even possible. As you listen, ask yourself, when someone cuts a tether but doesn't flee, is that a technical violation or a serious red flag? And how should courts handle accountability when mental health and compliance collide? Stick with me, there's a quiet but decisive move near the end that changes everything about whether he walks out today.
Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the forensic center. I've prepared an order, and we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my...
Right here, the court orders a forensic examination. This is essentially the gateway to determining whether Mr. Peoples is competent to proceed. A competency evaluation doesn't decide guilt. It answers whether the defendant can understand the proceedings and assist counsel. Notice the efficiency. Without objection, that matters, because it signals both sides recognize evaluation is appropriate. For you at home, when a competency order enters, timelines often shift, hearings may pause, and the court will schedule follow-ups based on when the evaluation is completed. Question for you. Do you think competency should be reassessed more than once if behavior changes during a case, or is one thorough evaluation enough?
Next day. I mean, let's see how. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just
That was last week. All right. So set a competency here, October 2025, 9 a.m. All right. What are we doing on the other case?
Listen to this muddle over dates last week versus setting competency. In October 2025, at 9 a.m., that kind of calendar confusion isn't just a clerical hiccup. It can delay everything, including custody, status, and treatment planning. For defendants awaiting mental health evaluation, clarity on timing can mean the difference between sitting in custody longer or getting into services sooner. Courts deal with overlapping dockets, multiple case numbers, and parallel conditions. Viewers, have you ever seen a judge stop and untangle dates live like this? If you were the judge here, would you lock in a hard date now or wait until the forensic center confirms completion to avoid another reset?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326.
Well, it also arose with tether.
Which is charged as a felony, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's listed.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion, I think something substantive that gives the court a better idea.
Defense asks to continue our plea of mute. That means the defendant stands mute and the court enters a not guilty plea on his behalf, a standard procedural protection. Then we get the crux, a bond violation tied to tether tampering. Now, charged as a felony in a related case. That's big bond conditions or promises to the court, and tampering strikes at the heart of supervision. But context matters. Was this a calculated attempt to abscond or a moment tied to anxiety? Courts often look at intent, behavior immediately after, and risk to the community. Audience poll: should tampering automatically revoke release, or should judges weigh mental health triggers when deciding consequences?
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
Here the judge focuses on a crucial nuance. The tether was cut, but Mr. Peoples didn't go anywhere. That detail shifts risk analysis. If the person remains at the residence and is compliant when officers arrive, the court may see poor judgment rather than an escape plan. Defense seizes the opening requesting return to home confinement. Prosecutors don't object to reinstating prior terms, but express uncertainty about the broader picture. This is classic courtroom calculus. Can structure and support mitigate risk? What would you do? Deny release to deter future tampering, or give a tightly monitored second chance because he didn't actually flee?
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I had a lot of anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at bench at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of anxiety that led to a freak out. Yes. And I felt like I needed to get it off me.
This is one of the most human moments. Mr. Peoples describes anxiety, claustrophobia, a freakout, and the urge to get the device off. The judge acknowledges hearing him without excusing the conduct. Courts increasingly recognize crises can drive non-compliance, but accountability doesn't disappear. The tightrope is crafting conditions that reduce triggers, clear crisis plans, rapid contact points, and swift but proportional responses if symptoms spike. Viewers, if a GPS device itself worsens anxiety, what alternatives should be on the table? Check-ins, therapy, milestones, or different hardware? And how can families be formally looped in so help comes before a violation?
Because it was claustrophobic and
Got it.
yes.
I hear you. Okay. All right. Here's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap.
Money enters the picture. Someone must pay for the damaged strap. That may sound minor, but it's a legal and psychological lever. Financial accountability reinforces that court tools are not optional accessories. The judge checks whether the family can cover it, signaling a path to reinstatement if costs are handled. Practically, these expenses constrain families already juggling transportation, treatment, and time off work for hearings. Should courts maintain hardship funds for equipment damage tied to verified crises, or would that remove necessary deterrence? Let me know what you think. Justice must be firm, but should it also cushion genuine medical episodes?
Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
Yes, Your Honor.
I give you another shot. You got to try to do the right thing.
Yes.
Okay.
Thank you, Your Honor.
All right. I'm going to do it. I think you can do it.
Me too.
Okay.
All right.
Yeah.
Thank you.
So what's going to happen is somebody's going to have to pay money for the strap that got damaged on your tether.
Understand.
I'm going to reinstate your previous bond where you were previously at home, right?
Mm-hmm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay. Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity Ann Arbor without necessarily violating a
Smart defense. Move here. Formalizing a crisis route of Mr. Peoples decompensates. Can he go to Trinity Ann Arbor without triggering a violation? The idea is simple. When health comes first, notify in real time and avoid penalizing life-saving choices. The prosecutor's response frames the operational piece. INFORM, community corrections immediately about where he is and why. Effective crisis clauses are precise who calls, within how many minutes, and what documentation follows. Viewers, if you were writing this plan, would you allow short walks supervised by family as de-escalation, or limit relief to hospital settings only?
confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response.
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office.
This exchange gets tense. The judge recalls a prior bench discussion about limited flexibility for brief walks during triggers. The prosecutor pushes back, clarifying she objected to a tracking tether change, not home confinement itself. The judge's stop talking moment underscores courtroom hierarchy and the need for crisp advocacy. Key takeaway: ambiguity breeds conflict. When liberty conditions hinge on mental health triggers, written protocols must be exact who authorizes, what distances are allowed, and how to log it. Would you favor a standing order that grants a narrowly tailored de-escalation walk with immediate notification? Or
the court would be apprised of what was happening, but the tether conditions that want to remain the same.
Actually, what happened last time was the public defender came up on our Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Ron. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here. Because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking. You huff one more time and we're gonna have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
I'm grabbing Mr. Wondering right now.
Your Honor, I'm very familiar with Mr. Peoples' case if the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case.
This is the quiet turning point. The judge aligns the new cases. $100,000 bond with the conditions of the existing case, so Mr. Peoples isn't trapped by a mismatched hold. That's practical, just as remove a technical barrier, so the true question becomes compliance under supervision, not paperwork mechanics. He'll be refitted with a GPS home confinement tether before release, and the family will pay $175 to community corrections. This shows how judges can harmonize multiple cases to produce one coherent supervision plan. Have you seen bond stacking block release in other cases? Should courts do this kind of alignment more often?
So that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid. And all prior conditions are reinstated. And then we need a new date, so when do we?
Your Honor, my request.
Well, I got the confident, it's actually going to be October 30th.
Okay.
It's going to be our day. So, all right.
Thank you, Your Honor. May I provide the court with the order to undergo forensic?
There hasn't been enough on this case yet, Mr.
I'm not.
No, go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's the order on the other case. I'm sorry.
Might be tomorrow, but as soon as you put the tether on you.
Okay. Sounds good.
We get the administrative closeout, orders signed, dates confirmed, and a reminder that nothing moves until the new tether is on. For defendants and families, this phase is where plans die or thrive, miss a payment, fail to coordinate fitting, or misunderstand curfew zones, and you're back in violation territory. Best practice: Day 1 checklists, 1 device fitting before transport home, 2 crisis plan contact tree taped near the door, 3 a calendar with the next court date and any evaluation appointments. For a call first rule, if anxiety spikes, viewers, what would you add to that checklist to keep this on track?
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
All right. Okay. Thank you.
The court ordered a forensic competency evaluation and, despite a serious bond violation for tether tampering, opted for a structured second chance. The decisive move was aligning bonds across cases, clearing the path for release under GPS home confinement once the $175 fitting fee and damage strap costs are handled. A crisis protocol is in place. If symptoms escalate, notify community corrections immediately and seek care, with the understanding that health interventions shouldn't automatically equal violations. Broader implications: courts are increasingly threading the needle between public safety and mental health realities, demanding accountability while opening clinical off-ramps during crises. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breaks.